Hello and welcome to this Russell-Cooke webinar on what to do as a charity tenant when your lease is due to expire. I'm Clare Garbett. I'm an associate in Russell-Cooke's specialist charity and social business team. I specialise in property law for charities, and within the team we also have people who specialise in governance and commercial matters, employment law and data protection law for charities. We also run a free seminar series where we get to meet you and tell you about an area of law, and you get to meet us and probably more importantly your fellow charities. Obviously, given the present circumstances, we'll have to deal with the electronic equivalent instead. The idea of this webinar is to give an overview for charity tenants on some of the issues to consider if your lease is due to expire. So to start with the kind of main points that you should be considering in the background as your lease comes towards expiry. First point is, what is your relationship like with your landlord? Are they likely to propose a completely unaffordable rent on renewal? Are they likely to want to kick you out in favour of another tenant who could pay more? Are they on the ball and paying attention, i.e. are they likely to take aggressive and immediate action if your lease, if you overstay your lease? Or are they actually not really paying attention and not really likely to do anything immediate? Do you actually want to stay, and for how long? Do you just want to buy some time in the premises at the current rent while you consider where you go next? Or do you want and need to be there permanently? Could you get a cheaper deal elsewhere, bearing in mind the duty on charity trustees to manage their charity's assets reasonably and responsibly? Are there other costs which might crystallise if the lease expires, which you would rather avoid at the current time? For example, if you're likely to have a repairing obligation under your lease. If you haven't kept the property in good repair, and sometimes even if you have, your landlord will at least try to get some money out of you for the money that's equivalent to the damage to their interests that's caused as a result of your failure to keep in repair. On the flip side, do you have money that's tied up, for example, in a deposit, which you'd actually particularly like back at this particular moment? And most importantly, what is the legal status of your occupation? Often charities have quite complicated positions with respect to the land that they occupy. They may have been there for a long time with a complicated background of negotiations with their landlord and a trail of different documents, which may make their position uncertain. For example, it's certainly not uncommon for us to be instructed by charity tenants who've been occupying property and paying rent for years, but in fact either have never had a lease in place or had one many years ago, but it was never renewed. You will have a radically different negotiating position depending upon what the legal status of your occupation is. And this is the main point that I'm going to focus on in this talk. Many leases, one of the things to be aware of as background to all of this is the effect of the security of tenure provisions for business tenants under the Landlord and Tenant Act 1954. A lot of leases won't have this protection because the landlord and the tenant will have agreed to contract out of this when they negotiated the lease. I'll come on to that and how you can tell whether your lease is contracted out later on in this webinar. However, I think it's useful to start with an overview of those provisions, as it will be relevant to a lot of the things we will come on to. The gist of the provisions is that a lease of property occupied by a tenant for the purpose of its business, and business in this context has a very wide meaning, which will cover pretty much everything that a charity would do from property. That tenancy will not end on its end date, but will continue on the same terms until such time as either the landlord or the tenant take specific actions to end it. Either the landlord or the tenant is also entitled, within certain timeframes, to apply to court for a new lease. If the tenant wants to end a lease that is protected by the Act, and I mentioned earlier some reasons why you might want to do that, then you have the option of vacating the property by the lease or by or on the lease end date. The continuation of the tenancy under the Act will only take place if the property is actually occupied by the tenant for the purpose of its business. Therefore, if on the date that the lease would have otherwise ended, you're not in occupation, then the continuation tenancy won't apply. If, however, you haven't done that, and in fact your lease is continuing under its terms, having previously expired, then you'll need to give 3 months' notice to the landlord in order to end that continuation tenancy. The other way for both parties to end the continuing lease is to complete a new one, either by agreement solely between themselves or by application to court within a set time frame for them to determine at least some of or all of the terms of the new tenancy. At that point of entering into a new tenancy, the continuing lease comes to an end, and I'll deal with this in a bit more detail later on. If the landlord wants to end the lease, then they have to give at least 6 months' notice to bring the continuing tenancy to an end. And in that notice, state that they are opposed to a further renewal lease and specify at least one of 7 grounds under the Act as their reason for opposing that renewal. I set those grounds out on screen. If the landlord is determined to end the tenancy, then they will know that they will, in due course, have to prove at least one of these grounds if the matter goes to court. They will also know that if the court were to order that a new lease were not to be granted based solely on one of the grounds that I've underlined, i.e. based solely on a ground which isn't the tenant's fault, then when the tenant vacates the property, the landlord would need to pay the tenant compensation at 1 times the rateable value of the property, or if the tenant and a predecessor have been in the property for the purpose of the same business for 14 years, then 2 times the rateable value of the property. You'll see from this that the negotiating position of the tenant whose occupation has the protection of the Act is improved just because of the hassle that the landlord will have to go through in order not to grant them a further lease. The tenant also has the benefit in negotiations for a new lease, if that's what the parties end up doing, of the fact that both parties know that the other party can ultimately apply for the court to determine the terms of the new lease if they don't agree. This means that negotiations are carried out against the backdrop of what the court would order. And therefore, if one party agrees at the request of the other to a term that the court wouldn't order, they may be able to extract corresponding concessions from the other party in exchange. For example, the court has to order that the new lease is a further protected lease and a further lease that has the protection of the Act, unless both parties agree to exclude the provisions of the Act this time around. Therefore, if as tenants you did agree in negotiations with your landlord to give up that protection this time around, then you should be able to ask for corresponding concessions from them, maybe on rent or something else, as in exchange for giving up this valuable right which you would otherwise be entitled to. Likewise, in fixing most of the terms of the new lease, the court will have regard to the terms of the existing lease. And so again, if you are negotiating against that backdrop and you agree a significant departure from the terms of the lease for the landlord's benefit, then you should also be able to ask for a concession from them in exchange for doing this. There's also a more general timing advantage in terms of rent. If, for example, you just want to stay a bit longer in the property at the current rent, it's worth bearing in mind that both parties can apply to court for an interim rent, which will be paid prior to determination of the court on the terms of the grant of a new lease. The interim rent is likely to be more than you're currently paying, but probably less than the market rent for the property. But the earliest date that it can be payable from is the earliest date that either the tenant could have put as the end date for the continuation lease in its notice requesting a new tenancy, or the earliest date that the landlord could have specified for ending the continuation lease in its notice. If one of you served the notice, the other one can't. In its notice, saying that it wants the continuation tenancy to end, and saying either that it's not opposed to the grant of a new lease or that it is opposed, and here are the grounds. Now, the earliest date that can be specified in either of those notices as being the date on which the lease will end is a date 6 months from the service of that notice. So going back to the interim rent point, if that won't kick in until the earliest date specified in the notice, then effectively you've got more or less 6 months at your old rent, depending on when the notice was served. So that's just something to bear in mind, is that you actually can buy a bit of, or you have a bit of time at your old rent before this interim rent will kick in. Also, when it comes to the determination of the rent under the new lease that would be granted by the court, if it did get to that point, then that rent would be a market rent subject to some provisos. But again, that wouldn't be payable until 3 months after the date that the court had finally decided whether or not, and the terms of a new lease, sorry, and whether or not to grant it. So effectively, you've got even longer at the property, not at a full market rent. So that's just something to bear in mind. Obviously, there are cost consequences when people have started serving notices and incurring legal costs. If you then were just to manipulate it in order to get a better rent, because of the way in which courts punish people who are incurring costs unnecessarily. But nevertheless, it's something to bear in mind. The tenant does still need to be careful during all of this to pay attention to time limits. If either party serves a notice under the Act and then neither party applies to court for a new lease by the end date for the old lease that's specified in that notice, and no extension is agreed between them, then the continuation lease and the tenant's right to a renewal lease will end, and the tenant will have no further right to remain in the property. So that's an overview of the security of tenure provisions for business tenants under the Landlord and Tenant Act 1954, for us to bear in mind as background throughout the rest of this webinar. Some tenants, as I said, will have this protection on the basis that some landlords who want to encourage their tenants to invest in the property and to feel that they've got security will give that security to their tenants, particularly if they're unlikely to want the property back themselves in the short or medium or long term. Other landlords will have simply failed to contract out of the Act, either because they weren't aware of the Act's existence or because they didn't follow the contracting out procedures correctly. And in some circumstances, which I'll come on to, the Act may start to apply by virtue of the payment and acceptance of rent and the creation by virtue of that of a periodic tenancy. I'll come on to that in a few minutes. However, because of the uncertainty of the position for the landlord under a protected lease, as discussed earlier, normally the parties will agree to contract out of the Act. In order to do this, the landlord has to serve a warning notice on the tenant, setting out the rights that the tenant is giving up, and the tenant has to reply with a tenant's declaration saying that they've read and understood this. And then the parties have to endorse on the lease the fact that that procedure has been gone through, and the fact that they agree that the lease will be contracted out of the Act. I've put the form of the endorsement on the screen. You usually find it towards the end of your lease. If you don't see this wording, then your lease hasn't been validly contracted out, because part of the contracting out procedure is putting this wording into the lease. If you do see this wording, then even if there were deficiencies in the procedure that was gone through to contract out, it's very unlikely that as tenant you can argue that the lease isn't contracted out, because it's quite clear from the wording of the lease that that was the intention of the parties, and effectively you would be stopped as a matter of conscionability from arguing that that wasn't the case. As I mentioned earlier, if a lease is contracted out of the Act, then the bargaining position for the tenant at the end of the lease is radically different than if they did have the protection of the Act. In this scenario, the tenant is likely to be a trespasser if the landlord has made clear that they don't want them to be there, a tenant on sufferance if they've overstayed their lease and the landlord hasn't made clear one way or another whether they're happy for them to stay, or a tenant at will if they've overstayed and the landlord is currently allowing them to continue in occupation. In all of these scenarios, the tenant basically has no security at all. Where you are a trespasser or a tenant on sufferance, the landlord can change the locks immediately without any previous demand for possession, subject to some safeguards which provide that if you're in the property when they try to change the locks and you clearly oppose re-entry, then it's illegal for them to do so. But obviously landlords would try and avoid that altogether by going in before you get there in the morning, for example. As a tenant at will, the landlord has to make a demand for possession to you, either formally or by demanding back the keys. But the effect of this demand will be immediate, i.e. it really doesn't give much more protection than being a trespasser. For this reason, generally our advice to a tenant whose contracted out lease is due to expire and who wants to stay is to negotiate a new lease as early as possible before lease expiry. However, there is one further possibility to bear in mind and be aware of, namely the possibility that a periodic tenancy has arisen. As I mentioned earlier, for a lot of our charity clients, their situation isn't actually as simple as a current contracted out lease ending. They may in fact be occupying and paying rent under a lease that expired years ago or under no lease at all. Even if that's not the case, it's useful to be aware of the possibility of a periodic tenancy arising because of the way in which it means that the longer you stay in the property past the end date, paying rent which is accepted by the landlord, the muddier the legal situation has the potential to become, which may be of benefit to you. A periodic tenancy is a tenancy which can be inferred from the payment of rent by reference to a particular time period, i.e. a tenancy which runs from month to month or from quarter to quarter by reference to the monthly or quarterly payment of rent. The basic position is that the notice that is required to end such an arrangement is equivalent to the periods by reference to which it runs, i.e. if the periodic tenancy is a quarterly periodic tenancy, then the landlord will need to give a quarter's notice to the tenant to end it. But it does get more complicated than that, because returning to the Landlord and Tenant Act 1954, the landlord and the tenant can only contract out of the Act where the tenancy is for a fixed term. By definition, a tenancy which continually rolls over from week to week or month to month isn't for a fixed term. As a result, a periodic tenancy will attract the protections of the Act, and therefore in reality the landlord will end up having to deal with all of the difficult things that they were going to have to deal with in the scenario we mentioned earlier where you have a protected lease. Whether a tenant's occupation is merely as a tenant at will or has become a periodic tenancy is a grey area depending on a lot of factors. Generally, the more the landlord has made clear that they don't want a periodic tenancy to arise, or that they are allowing the tenant to remain in the property just because they happen to be in negotiations for a new lease and they actively pursue those negotiations, the more likely the position is that it's a tenancy at will. Conversely, the longer the situation persists and the less the landlord objects to a periodic tenancy or proactively negotiates a new lease with you, then the more likely it is that the arrangement will have become a periodic tenancy. The position is often basically uncertain, and uncertainty can obviously be stressful for both parties. And as I say, where it's quite clear that the contracted out lease has just ended and therefore it's very likely that you're a tenant at will, our recommendation would be that you enter into lease negotiations as soon as possible. However, uncertainty can sometimes be your friend, particularly where, and as I said, this is actually quite common for charities, the situation is genuinely muddy. In this scenario, you may well be able to leverage the uncertainty and the risk for the landlord that you have a protected tenancy, and therefore that it's going to be time consuming, difficult and expensive to get rid of you, to your advantage. And either specifically use the uncertainty as a negotiating tool for a new lease, or request compensation where appropriate for not taking a new lease. Or if your landlord is doing nothing, it may be appropriate to stay in the property paying rent in the hope that it gives you a longer time at the old rent. And also that the longer you stay there paying rent, depending on what the landlord's doing, obviously, the more muddy the situation is becoming and the greater rights you may be accruing. This is risky and it won't work in all scenarios. And I would obviously recommend taking legal advice on the position, but it is something to bear in mind where the circumstances allow. Anyway, that's hopefully given you an overview of the things to consider when your lease is about to expire. I hope you found it useful. If you have any questions about your own situation, etc., I'd be very happy to take a quick call about that for no charge. So please do pick up the phone or send me an email. Also, if you have any feedback about the webinar or any other topics that you'd like us to cover, please do let me know. Thanks for watching.